document we have up?
Okay, we're live.
Good morning and welcome to the House Environment Committee. This morning, we're going to continue discussion of H 230 with our legislative council.
Good morning, this is Michael Grady with Legislative Council. I'm still trying to navigate internet issues. Yesterday, House Judiciary looked at S 230 and specifically that part of the bill related to the department's proposal in sections 4 and 5 to change the jurisdiction or the initial jurisdiction of many fish and wildlife violations. As you might recall, most fish and wildlife violations right now are deemed to be criminal violations, except for 7 minor violations. And the department is asking that instead of the default criminal, there be a default civil jurisdiction unless certain circumstances occur which dictate that the offense be criminal. The Judiciary Committee looked at those sections. While looking at those sections, they asked Judge Zone to opine on the language that was in front of them. Judge Zone made some suggested changes, and you will see those suggested changes on your committee website with it's the House Judiciary Draft Amendment, draft number 1148/2025. And you will see in section 5 where the minor fish and wildlife violations are listed.
1 second.
Right,
We
yeah.
don't
I
have
think it's
to-
under Senate Judiciary draft language, unfortunately. It's
7.
H 230. Wait a minute. Let's see if that's it. Yeah, so I think.
It says Senate Judiciary, it should say House
Yeah, it
Judiciary,
should-
sorry. That was probably me.
All right.
So this is the
You have
3-page
it, right?
document.
It's a 3-page document. Yeah.
Here it is.
Okay.
Oh, no, that's not it. It's because that's 16 pages.
Are folks finding it? Don't change it quite yet. Let's let people just
This one,
get through it, then we'll see.
but it's 4/7. See,
Okay.
that's a Senate.
That's it.
Oh, that's the one we're looking at?
Yeah, 1 to 3.
Okay, sorry.
It's supposed to be house where it says.
Yep.
CC Holloway.
Yes.
Okay, does everybody have it up?
Yeah.
So in section 5, where the minor fish and wildlife violations are listed, you'll recall that the department recommended that except for big game offenses and under revocation offenses, which are when somebody's taking game under suspended or revoked license, and the offense is not otherwise listed in the section, so it's not otherwise a minor violation, shall be charged as a minor violation, provided that the offender has no prior history of fish and wildlife violations. The language yesterday said that there was no need to seize in order to further investigate the violation, and Judge Zone said, well, that injects maybe a subjective element into it. It objects a continuing timing element into it. There is dispute among courts and enforcement agencies about need for seizure. And he recommended that this should all be past tense. It should all be where nothing was seized. The offender had no prior history. It was a determination and the ticket is issued. So that is what the changes in section 5 do. So instead of saying there was no need to seize evidence, no evidence was seized in order to further investigate the violation. It's simply under C, where it had previously said there was no need for a criminal warrant. a criminal warrant was not used to further investigate the violation. So it's all very objective. Remember how we started out this conversation? There were subjective determinations made by a warden in the field that could have led to divergent or different results for the same offense with an offender of the same circumstances. Now this is all objective. Something happened and or didn't happen, and the warden or law enforcement officer then refers it to civil court for review by the Judicial Bureau.
I understand that logic, but I guess was imagining this all, I thought it would happen in real time. And that the officer I thought the ticket would reflect the charge.
Well, that's what Zone was saying, right? Zone was saying, you're gonna go out there, you're gonna write a ticket, and once you've written that ticket, you've decided that there was no prior history, that no evidence was seized, that no criminal warrant was necessary, and there's no possibility of forfeiture. Once you write that ticket, you've made these determinations.
All right, Representative Austin.
Yeah. So, B, no evidence was seized. Is that subjective to the warden?
No, it's like they literally don't take the firearm, don't take the ammunition, don't take anything related to the offense. They don't seize that evidence. They just write the citation.
So it's not, no evidence can be seized? I'm confused because it seems subjective, like
No, so this is when it's going to be civil.
Yeah.
No evidence was seized. If evidence was seized,
Yeah.
it's going to be criminal. It's not that the violation isn't enforced. It's now going to be referred to the criminal division.
Representative Pritchard.
So ticket could also mean warning in this case.
Well, they did not address that question. That question was addressed in language that was submitted by the department on Friday, but I don't think it reflected your intent.
Oh, sorry, go. Yeah, I want to talk about that.
Because I asked the chair if you wanted warning to include
Violation to include.
to be included as a violation, and it was indicated that that wasn't your intent.
So we had that conversation and then it was a little bit unclear. I think at the end of it, I had asked Fish and Wildlife to go and include language that was being recommended for them. They said, we are considering a violation includes a warning. And then we had a pretty extensive conversation, but somehow lacked enough clarity. And then I kind of reconsidered and was like, wait a minute, I think that's where we landed actually, was that a violation does not include a warning. So this is one of the things we need to talk about, but others' thoughts on that? Representative Pritchard.
That wasn't my intent.
That was or wasn't?
Wasn't my intent.
You'd like a warning to be included?
I think so.
So actually, one thing I would like to just talk with all of you about is, it seems to me, particularly Representative Pritchard, you've reminded us that the nuances of, like, the deer season they're pretty intricate. And it seems right to me from the outside. I used to hunt deer, but I don't anymore. But like watching those changes that take place every year, that someone could find themselves really thinking they're doing the right thing, but not being completely aware of where they were, which could result in a warning. And really, or take a slot limit. You could catch a fish and it could die and you end up with it, but it's not a legal fish. Where are you in the scheme of being a violator?
Well, I think there's a difference between intent. I think a warden's pretty good at figuring that out. And an honest mistake. I mean, as far as the slot limit goes, I mean, if you hook a fish in, the guts, you release it. I mean, by law, you have to release it back into the the lake, it's gonna be dead, it's a dead fish, but, I think clearly in that case, that's what you do. You don't say, well, I knew he was gonna die, so I kept him anyways. But I think there's varying, and I don't think there's a lot of them. I just think that, what I don't want to do is send the wrong message. And we talked a little bit when I talked to Justin. I mean, Corporal Stedman used to do when he first started, he would come, I would invite him to the hunter safety classes, and he would do it, give his speech. And part of that was that, listen, sometimes we make mistakes, and the right thing to do when you make that mistake is to call the warden, and we will treat you fairly. And I think, I think that's an important message, especially for people getting into it. I mean, things have changed so much. Our culture's changed.
But I feel like that aligns with what I'm saying, which is because what happens, and I think Ella will speak to this in a minute, is if you made an honest mistake and got a warning, the way this is written, that's a violation, and your next offense is a criminal one. And you've all of a sudden flipped that switch.
For the same warning or any?
Any
going
warning,
forward?
any warning.
So I don't know how a warning would be handled in the Judicial Bureau. Because generally the Judicial Bureau sets default penalty payments for a violation that it has jurisdiction over. And then final penalty amounts if you choose to challenge the penalty. What does a warning get?
Hannah Smith with Fish and Wildlife. It appears on your record in Valcor, the law enforcement database. It's not processed by the Judicial Bureau. There's no fine.
Representative Chapin.
Can you fight a warning? You challenge it.
It's a good question, and I don't want to speak out of turn. I don't think so,
Yeah.
because it doesn't go any farther
No.
than appearing on your record, but I honestly don't. I'm not sure.
So having spent 2 years in the judiciary and just being a human being, I don't see how we can hold someone to a criminal penalty because they had a warning that they couldn't challenge. There's no due process there, so I don't see how that follows any sense of logic or maybe even law.
Others have thoughts on this?
Just so I'm clear,
Senator
what
Moore.
we're saying is that we're saying in number 8 capital A, the offender has no prior history of fish and wildlife violation. What we're really arguing about is whether or not that word violation includes prior warnings.
Right, that's what we're
And
talking
what
about.
we're arguing is that it should not include prior warning. I think that's what we're saying.
Well, we're talking about it right now. Yeah.
Well,
That's what I'm.
Right, that's what-
Representative
a
Richard.
simple one is, for example, and I worry about this all the time when I would out hunting or fishing. And when I buy my license January 1st, I make like 6 copies of it. I put one in my glove box. I put one in my wallet. I put one in my backpack, and so on and so forth, because I don't bring my cell phone. If I'm stopped by a warden in the woods, in the middle of the woods, and he asks for my license and I don't have it in that pack, that's a violation. But even though I bought my license, I have a license, I paid for my license, under the statute, it's a violation because I have been unable to show it to the warden. So to count that towards I guess that's what I'm saying. Is it really, I guess it is a violation, but are these the people that were really trying to, that are causing the problems and being disrespectful to the resource or plummeting the resource? They're not. They're folks that made an honest mistake. And it was certainly not intentional.
Well, I think that's an argument for not including a warning, because I think wardens have said, like, we give people warnings for that kind of, like, and they don't then for their, if they had another one, they wouldn't automatically because of that warning. And I think they wouldn't toggle into being a criminal.
Yeah.
Representative Bartholomew.
I guess I'm just struggling with this one because both sides of the argument make a lot of sense. It does seem to me that if you did something wrong and you get a warning, you've done something wrong and you didn't get a ticket, it wasn't taken farther, but you wouldn't have gotten a warning if you hadn't violated something. I'm kind of having trouble getting past that. And I guess it kind of comes down to if someone makes an honest mistake, should they be issued a warning? And what are the wardens actually doing out in the field? Are they giving warnings when, oh, this guy screwed up, I'm not gonna just don't do it again? That's a warning, but it's not a warning.
And what is the history of the warning? Because a warning, one would think, could just be the warden saying,
Don't do it again.
don't do it again. And if I find you doing it again, and I guess it's a way, because we have multiple areas of jurisdiction with different wardens working, for them to know that they've done that. But it seems that it does go on your record and you can't fight it. And so that's
So does anyone know how wardens behave? I guess it wouldn't be uniform, depending on the warden, how they handle it.
Representative Chapin.
Whether they were having a bad day.
What I heard from the Fish and Wildlife Department was that they brought us these provisions because wardens right now are both issuing lots of warnings because in many situations, they feel like a criminal penalty isn't warranted, but a civil penalty would make it so that they would issue far fewer warnings and potentially fewer criminal violations and have this in between that is a larger pool of civil violations where people are held accountable, can fight it, and then it's a violation. And then you would take the next step to a criminal violation. And so right now, what we heard was that behavior of the wardens is inconsistent across regions and is heavily leaning toward way more warnings than penalties. And that in using these tools, adding these tools would enable them to train wardens to issue more civil penalties and then criminal penalties where appropriate. And so we're trying to decide the appropriateness. So what I'm arguing is that given that they're trying to go from many, many warnings and few criminal penalties and very few civil penalties to more civil penalties, fewer warnings, that it doesn't make sense. We're trying to encourage warnings where warnings are appropriate and penalties where penalties are appropriate. And right now, wardens are leaning too heavily on the warnings. That's what I thought we heard.
And to an extent, you're always going to have some variation because all law enforcement for each singular offense has what's called enforcement discretion to determine whether or not to charge or cite. And so that is something that's a case by case basis.
And did our Judiciary Committee look at this, one of this item,
About whether or not,
warning violation?
no, they did not.
Yes, yeah, we sent it over. Representative North.
How do we want to look at this series of criteria here? Do we want to look at them as if any one of these trips, you have to call it criminal, or do we want to look at it as these are the things to consider to make it criminal? And that we could, that there could be discretion on the part of the ward to say, yeah, you've tripped one of these, but the other three haven't, and I'm still going to call this a minor.
Well, that's where you started out in the language from the department, but that created an issue of different people being assessed different types of penalties. One would be civil and one would be criminal based on the subjective decision of a warden in the field. And that raised issues with me under the Common Benefits Clause. It raised issues with Judge Zone and the subjective nature of the decision. And so moving away from the subjective determination to an objective determination The law enforcement officer will still have the discretion to decide to charge or not. But they don't have the discretion if these factors are met to decide whether it's going to be criminal or civil. If the factors are met, it will be criminal. Remember, everything's criminal now except for 7 violations. By the way, failure to display your license is a minor violation, so it's always going to be civil. So that's you're shifting from the default of criminal to the default of civil and setting up criteria for when a violation can no longer be considered civil because of significant factors like need to seize evidence, forfeiture, need for a warrant, prior bad history. And they are all objective determinations, not a warden saying, oh, this is my cousin Fred. I think for Fred, I'm going to put this into civil instead of Fred's neighbor, who I don't like, going into criminal.
Representative Austin.
Yeah, I assume these are like the warnings and the minor violations are deterrents for people to repeat the behavior. Do we know if one is more powerful in stopping, like people, if they get a warning, do we keep track if they get another warning? I mean, do they tend to not offend again?
I don't know the answer to that in regards to deterrent effect. One has a monetary penalty and one does not. And I think that usually is more of a deterrent.
Spent a lot of time on this. So there, last comments, we do need to move on or Representative.
I agree, that I'm concerned about due process. Someone doesn't have due process with the warning.
Yeah, so does anyone object to the language the way it is now? Representative Norris.
Thank you. Where we are assuming, Representative North. I think that's what you said, right? Representative North?
Morris.
I'm sorry. Sorry, go ahead. Yeah. Okay. Just to clarify what you're saying, is the language as it stands, where violations means violations and not including.
Right. Representative Morris.
That's one of my questions, that A, the offender has no prior history of fish and wildlife violations. That's the criminal violations. That's not the warning violation.
Any violation.
So let's talk about what that means, because there's actually a definition of what a fish and wildlife violation is. And it's in 10 VSA 4551. And it's basically a violation of the part unless it's determined to be a minor violation. So a violation of any provision of this part other than a violation for which a term of imprisonment may be imposed or a minor violation shall be a fish and wildlife violation. So anything that's a violation of the part, and the part is, you all know what the chapter is, you know, all know what a section is, but in between chapter and sections, there's parts. And parts are collections of chapters.
And where do regulations fit in from changing season to season?
Those are listed as anything that's a violation of the part, and the rules adopted under the part are violations.
Okay, are we good on this section? So now Representative Bartholomew.
Remind me, who has possession of this bill?
We do. They did a flyby and they're proposing an amendment.
So I don't understand why we need to do, why can't we just incorporate this? Why do they need to, they don't need to amend it.
They did, that is just how I drafted it.
Yeah.
So that,
We're going to
I'm
incorporate.
just confused.
Right.
Okay,
Going to,
all right, got
we're
it.
talking about, are we going to incorporate this language?
I'm just confused by what we're presented here.
All right, does anyone have objections to incorporating what the judiciary has sent us, or do we want to talk about this till noon? Representative Morris.
I've had lunch, so noon's okay. Thank you, Madam Chair. When the idea of warrant or a warning first came up, I was not necessarily in favor of including them as a violation. However, with the Valcor system or the documentation system that they have, now all those things get captured and they can see them again at a future date, including warnings, which complicates this in my mind. It's going to pop up as a previous violation, a warning, and now it could be taken to a criminal if for the next one.
If it's a warning, we are now talking about not including that. That's what we've been talking about.
And I haven't seen how Valcor displays in probably 4 or 5 years. But it tells you the nature of the offense. So I think they'll have the ability to say that was a warning and it doesn't count as a violation.
I'm good with that. If I wasn't listening, I apologize. My mind works
All
linear.
right. At the risk of confusing things further, is there, could either you, Michael, or Hannah, just briefly summarize how this then will interact with the interstate compact?
Do you want to do that?
This is Hannah Smith with Fish and Wildlife. And the Interstate Wildlife Compact is essentially an agreement between states. Most states are participating, that it requires states to treat out of state, non-resident and residents the same when they commit a violation in the state. And then it also imposes reciprocity when it relates to revocation or suspension of licenses. So if somebody's license is suspended in a participating state, Vermont typically, and we do have discretion, but we almost always will similarly suspend their license if the suspension would have resulted in suspension in state. I know it's a little bit confusing, but the larger point for this conversation is that if you committed a fish and wildlife violation in another state that resulted in your license being suspended, it doesn't appear in Vermont's law enforcement database as a violation having occurred in Vermont. It's just that your hunting or fishing license is suspended. So it's an agreement that results in license suspension or revocation. It doesn't change your criminal record in Vermont if you've not committed the violation in Vermont.
But if you were under vacation in another state, and you committed a violation in Vermont, you are going to criminal.
Yes, because that's actually the language. It's an under revocation offense because you committed a violation without a valid license.
So I think that's my concerns, I think, are addressed by that, because if they're gonna just treat that as under revocation offenses, you don't have that debate about whether or not it should be criminal, whether it's a violation or not. It's just an under revocation offense that goes to criminal.
Okay, great. Folks have questions on that? Okay. Okay, I think that the final thing we would like to talk about is yesterday we did hear from a representative from the Farm Bureau who also has her own small farm, and she had thoughts on the deletion of section 11. I guess to summarize, well, at least the parts of that testimony that I recall. Well, I have a question actually for you, Hannah. And Michael, because when I read this language, it seems like that there's a $5,000 limit on the amount that a farmer could receive in kind of for crop loss from the Fish and Wildlife Department. But when I look at the list of I don't know what you're saying, but per year, right? Yeah, per year total $5,000, but the payments out, many, like a couple of them well exceed that amount. And why is that?
I reached out to several staff who've been involved with this over the years. And I know that there was a very large payment paid out in 2024 I was trying to get to the bottom of that. I'm not sure what happened in that instance. I think that there was, it's possible that because I know that the $5,000 cap, I think, went into effect June of 23. So nothing should have, nothing more than $5,000 per person should have been paid out after that. I don't know if it was damage that occurred prior to the violation, prior to the cap going into effect. I reached out to prior general counsel, and I haven't gotten an answer.
Interesting.
I read that language the same way that you do, that it would be a $5,000 annual cap per person, and a person can be, a farm.
And there's another one on the list that maybe does predate that at 50,000.
Yeah, it was the same farm. I think it was the same farm.
Yes, it was.
And I can provide more history as I get some.
So the other, do you have a thought on that? The other thing that came up yesterday was sort of reading this as really a Fish and Wildlife Department. I guess I'm curious about the history of this section of statute, because it comes across when you look at it as a way of keeping land from being posted more than other or equally important to reimbursement for crop damage. Like you can only apply for this if your land is not posted. And it seemed like that was an interesting link.
Yeah, I think that was added in 2011.
Whole thing.
No, the whole thing was 1969. That was the first edition of the compensation for crop damage. But in 2011, there were significant changes to provisions related to posting, because people were putting up signs actually complying with all the requirements for registration. Therefore, getting the benefit of posting while also still qualifying for things like this, or like the antlerless deer, or things like that. So there was that language that was added in as the last sentence of sub A, as used in the section, post meets any standards that would lead a reasonable person to believe that hunting is prohibited. So I mean, I believe that 2011 was when the posting requirement was added, and if it wasn't 2011, it was 1997. But I can, Jamie, can you hand me Total 10 Part 2?
Section you said? Part 2. Part 2. Thanks.
The 2011 added the last sentence in sub A. Now, the posting language has been there since 1969.
Oh. Sorry, did you just change your mind?
Yes.
It's been there since 1969.
Yep.
Okay. Michael, would you like this onion?
What?
Sometimes we hear the cafeteria. Representative Chapin.
So question for Fish and Wildlife. So I read this provision, and now that we determined that it was originally crafted as an incentive to not post land for farmers, while also compensating somewhat for some damages. I guess my a little question I have is, one of the 5 folks who have been reimbursed in the last couple of years lives in Montpelier, according to the spreadsheet you gave us. Montpelier doesn't allow hunting within city limits, so I'm wondering why someone who doesn't need to post their land because hunting's already not allowed on their land is getting reimbursed under this incentive to not post your land.
Because his land isn't posted.
I mean, I think that if you read the language, it doesn't say anything about municipal regulations that would otherwise restrict the activity. It applies across the state to everyone. Yeah. And presumably the department never tried to parse that out to create more equity.
Yeah, so it just does bring up equity questions for me. And to me, having worked in agriculture for a long time, I just think risk management for agriculture should be focused on risk management for agriculture. This whole provision really confuses me. I mean, I'm super supportive of farmers having some compensation for crop losses because I know how underinsured or uninsured so many of our farmers, especially in our small, very diversified agricultural state, struggle with this issue. But this whole provision doesn't make sense to me.
Oh, so you support deleting it?
I do.
Yeah. Any further discussion on this section? Being deleted. It is proposed to be deleted, and Ella is saying she supports this deletion. Does anyone not? Representative Nor?
I guess I don't understand. If we're concerned about providing support for loss for small farmers, why are we wanting to delete it? Wouldn't we just rather modify it a little bit? Does the protection for small farms for loss appear somewhere else? It doesn't have the caveats that this one does?
I mean, I think if we want to discuss, I mean, the department is asking us to delete this. And so I'm supportive of that because I don't think this equitably addresses crop losses for agricultural producers. And so I think the Ag Agency and USDA, who provide crop risk management, should be supporting farmers on crop risk management.
So it is handled somewhere else.
Well, I think that these losses that we're specifically talking about here are small for specific kinds of losses.
Mhm.
I know are often people are under or uninsured for those losses. So I'm not saying that these people can get this money elsewhere, but I'm saying other agencies and entities provide risk management and crop insurance. And like the farmer spoke about yesterday, if you're going to be providing insurance payments, you should also be providing the requirements that help people address the risks
Mhm.
instead of just having this payment that really is about not posting your land. So I think we're paying farmers here to not post their land. And I'd rather see the Ag Agency and the USDA appropriately support our farmers with more stronger, comprehensive risk management tools.
There's also another risk management tool available under USDA. You can contact APHIS and they have an animal, I can't remember the exact animal control service that will help you deter wildlife on your property.
Yeah.
Thank you, Ella, for that explanation.
And I'm interested in getting more information on the $149,000 payment that went out.
Yeah.
Because that seems outstanding in its field. All right, further discussion on this? Representative Pritchard.
I mean, the department's reasoning basically was the financial loss that they suffered
Yes.
funding this, right? Yeah.
So we have a proposed language change that I'll ask our council to integrate into the next draft of this for us. Are there, yeah, we were hoping to get to, is there any update? I know our Judiciary Committee also looked at 86
They're continuing to take testimony today.
on 86.
Yes.
Okay. Can you summarize their concerns or where they're?
It's similar to the discussion and debate in here, whether or not the limitation on liability is going to remove remedies for persons that are hurt or damaged from snow or ice. Why would you do that? Said it's a policy decision to help incent good behavior so that you are not forced into a TMDL where you're required to do the behavior anyway. And I had to leave early because I had to go write a pretty significant revision to the right to farm law and other things. So I did not see all of the end of the testimony.
All right, I think let's take a 5-minute break. And or I guess maybe a 10-minute break. And then we'll shift gears to 303.